Well, thank you everyone for joining us today for a very special presentation. We are going to be discussing the Uniform Healthcare Decisions Act that went into play on September 30th of 2025. My name is Paula Waite. I'm one of the education chairs here for Delaware Quality of Life. I'm speaking on behalf of our president, Terry Tegmeyer, who is currently on a plane going on a family vacation. So I would like to just introduce our guests that are going to be giving our presentation today. We have with us Jessica Prestipino. She is an attorney with 13 years of experience in the healthcare industry. She previously worked with a pharmaceutical company and health insurance company within their regulatory and legal departments. Most recently, Jessica earned a certification in healthcare compliance. Her current role is Associate Corporate Counsel at Christiana Care. We're also joined by Chris Otto. Since 2020, he has served as the Executive Director of the Delaware Nurses Association. He also maintains a clinical practice as a bedside nurse in the Neurocritical Care Unit. He's board certified as a critical care nurse. He's the editorial board member for the Journal of Nursing in 2025. And I find this one detail, it's very cool. He was selected 3 times as one of the most influential 222 Delawareans by Delaware Business Times. And in 2025, he was recognized by the Delaware Business Times as 40 under 40 honoree. And he's also Delaware Quality of Life's advocacy chair. So welcome everyone. I'm going to turn it over to our speakers and I'm going to leave it up to them. Do you want them to ask questions via chat or do you want them to raise a hand?
Do you think chat, Chris?
I think chat. Yeah, I think we'll keep a close eye on the chat. Jessica and I are going to obviously tag team this presentation, and I'll start us off. Jessica will jump in, and vice versa. So we'll monitor the chat for questions as the other one is speaking.
Great.
Awesome. And can we have the slides? Awesome. Thank you, Casey. So I'll get us kicked off. We're excited to be here with you today, bringing you both the clinical perspective as a practicing registered nurse and my role with the Delaware Nurses Association, being involved in the passage and advocacy around the Uniform Healthcare Decisions Act last year, as well as Jessica's legal perspective, working in healthcare and dealing with these issues from the legal side. So we have a unique dual perspective for you today. Next slide, please. To kick us off, some of the highlights of the new law compared to previous versions. The last time that the law was actually updated was in the 90s. So it was due for an update and underwent some comprehensive changes. In the new version, there's an expanded definition of what an advance directive is, how to create one, as well as an updated in the actual statute, an updated example, template of an advance directive. Brand new and with great advocacy from the Behavioral Health Consortium. Now there is a dedicated advanced mental health care directive. So an individual can have both a general advanced directive for healthcare instructions, but specifically and dually a advanced mental health care directive with more specific instructions on their preferences, wishes, providers, institutions related to their mental health care. We have an expanded list of who can actually perform capacity evaluations, and we'll talk more about that. Patient notice and objection to the capacity evaluation. So there's more requirements on the provider's part to document, communicate, and document again their communication with patients or surrogate decision makers, powers of attorney regarding findings of lack of capacity. Additionally, there are a expanded list of default surrogates. So we're all familiar with when an individual is found to lack capacity, there's no power of attorney in place. We have in statute a hierarchy list of who becomes the default surrogate decision maker, starting with the patients or individuals married spouse or partner, and going from there. So there's some updated default surrogates that we'll talk about and go through that hierarchy, as well as, and in particular from the clinical perspective, this becomes very helpful. Reasons for disqualification of default surrogates. So in law, there are now actual reasons that the healthcare provider can disqualify a default surrogate decision maker from that list and essentially move down that list to the next default surrogate decision maker. There's update to guardianship notice, which Jessica will talk more about, as well as talking about how a healthcare institution and or provider can actually decline a patient's healthcare instruction. So we'll talk about what a healthcare instruction is, how it's created, and then what happens when there's conflicts or that particular healthcare instruction cannot, be followed by the healthcare institution or provider. So a lot to cover in the next hour. We welcome your questions and engagement, and we'll provide our contact information at the end should additional questions and follow-up be necessary. So thank you. And next slide, please. One of the main guiding principles of the Uniform Healthcare Decisions Act is really stressing that all adult patients are presumed to have capacity. So in order, if there's question and in order to initiate the process, you really have to have a significant finding or suspicion of lack of capacity, but otherwise all patients are presumed to have capacity. And that includes making or revoking their own healthcare decisions and instructions, as well as appointing or removing their potential healthcare surrogates. So right off the bat, individuals can identify who and who not they would like to serve as healthcare surrogates. When that individual is found to lack capacity, then and only then is when the surrogate decision maker shall be identified and activated and utilized to make the healthcare decisions on behalf of the patient in question. Those decision makers, the surrogate decision maker or power of attorney, must be willing and able to make the healthcare decision in a timely manner that is in accordance with the patient's known wishes. This is explicitly written into the law in a few places and gives healthcare providers a little more basis to communicate with families moving forward, and disqualify surrogate decision makers if they are not, acting, responding to, or communicating with the healthcare team in a timely manner. And that's an important evolution for us because I know I have been in situations, and I'm sure other providers can think of situations where the family stopped communicating with the healthcare team, phone numbers weren't working, you weren't able to get a hold of individuals, and you were left in limbo, wondering, what the patient's next care decision was going to be. So if you are unable to contact and the default surrogate decision maker is not, participating in care, answering phone calls, showing up to meetings, that is basis for disqualification, which again, we'll talk more about shortly. But really understanding the presumption of capacity as the guiding principle for this Uniform Healthcare Decisions Act. Jessica, anything else to add there?
No, you did a great job. Thank you.
Okay. Next slide, please. And feel free, like we said, Jessica, jump in at any point. Just a quick overview of some of the available healthcare planning tools. Of course, we have our gold standard, the Advanced Directive. This is the patient-provided healthcare instructions, whether it's written or verbal, that indicates, the patient's goals, preferences, or wishes concerning their health and medical care. This can be created by the patient at any point, directly via written or verbal instruction and verified by a witness. This does not require certification, from an attorney or otherwise. This can be documented and witnessed via signature from certain individuals. Of course, power of attorney for healthcare as well. This is now a legal document that indicates a patient's desired instructions and names or identifies another individual as the agent to make medical decisions on the patient's behalf should that patient lose capacity to make their own decision. This must be in writing, dated, and signed by the patient, and again, witnessed by one or more adult individuals who are not directly named in the document, who are not, if the individual resides in a long-term care facility, the witness cannot be an owner, operator, employer, contractor of that long-term care facility where the patient resides. So some important nuances to understand when it comes to the creation and witnessing of advance directives and power of attorneys for healthcare. As discussed, the Advanced Mental Health Care Directive, this is a specific document focused on the individual's mental health care and instructions for mental health care. It can include patient preferences regarding mental health care professionals, programs, facilities, medications, crisis interventions, and duration of admissions. Again, this is the patient's wishes and preferences. There are still additional laws that apply regarding commitments and holds and things like that, but the patient now has the ability to express their advanced mental health care instructions and wishes and decision makers for mental health care decisions as well, should they find, lack of capacity. We'll talk about this later, but I just want to note while on the topic, an individual can have two power of attorneys, one for general health care and one for mental health care. So that's an important advancement that we need to distinguish now as healthcare providers and understand that we may be dealing, depending on what the patient's presenting with, two different power of attorneys, one for general health care instructions and the other for mental health care instructions. Next slide, please. Additional healthcare planning tools, living will. This does require an attorney legal document that includes patient's healthcare instructions on what medical treatments or care a patient would want or not want if the patient had certain qualifying conditions. A lot of organizations use goals of care, 5 wishes, conversations as healthcare instructions, verbal or written, and those are still in play. And additionally, I'll mention it's not on the slide, but we're all familiar with DEMOS, or the Delaware Medical Orders for Scope of Treatment. That is another healthcare planning tool that comes into play and is related, but certainly different from the Uniform Healthcare Decisions Act. That DEMOS form is a statewide standing medical order regarding scope of treatment, life-sustaining and life-limiting treatment options. There is a DEMOS steering committee, and the Delaware Quality of Life Coalition works very closely with that DEMOS steering committee and is going through some updates and transitions now relevant to the Uniform Healthcare Decisions Act. Of note, when there are multiple conflicting healthcare instructions made by a patient, and the new one conflicts with an earlier healthcare decision, the latter revokes the earlier. So the most recent healthcare instruction is the one that the healthcare team needs to be following regarding and only regarding the extent of the conflict. So again, important distinction when we often, patients change their instructions based off of changes in condition, new diagnoses, things like that. It's important for us to continuously keep the medical record up to date, engage with the patient and their surrogate decision makers, and know when a conflict exists and do our part to resolve the conflict based off of the most recent healthcare instruction provided to us. I did see some questions coming through the chat, so I'll just pause and see if we can answer those. Is the mental health care directive available on Delaware.gov? There is, unlike the general advanced healthcare directive, where there's an example form that patients can use, there is not a example advanced mental health care directive, but in the statute, and I encourage everyone on the call today to review the statute. You'll see it cited throughout the presentation. There is examples of what can and cannot be included, but there isn't from what I found, and correct me if I'm wrong, Jessica, but there isn't, and like advanced healthcare directives, a gold standard or example mental health care directive on Delaware.gov. Something for us as a coalition to look into and take back. Um, Question about who may witness, employee of only a long-term care facility or any facility. Um, it's a matter of where the patient resides. So if the patient resides in a long-term care facility, no employee of that facility can serve as a witness. If the advanced healthcare directive is made in another setting, then that becomes null. It's all about where the patient resides. Um, what specific determinants are used to determine capacity? We're going to talk about that in the next few slides. These should be mandated evals, meeting national health standards, subjective and done by team med experts. So we'll come back to that and make sure that we answer that question, Bessie. But let's go through the next couple slides first. So just a quick overview of healthcare instructions. These are, an instruction that the patient can create that expresses their preferences for future healthcare, including preferences regarding any of the following: professionals or institutions, how a healthcare decision will be made and communicated, persons that should or should not be consulted regarding a healthcare decision, a person to serve as a guardian for the individual if one is appointed, and an individual to serve as a default surrogate. So if the healthcare instruction is documented before, the patient loses capacity or, is unable to make decisions, that becomes the default surrogate decision maker based off of that healthcare instruction. We have responsibilities as healthcare providers to document these instructions in the electronic medical record and date the instruction that the patient has given us in that medical record, as well as communicating the instruction and date of instruction to administrators, employers, other providers, the interdisciplinary team. So that is explicitly written in the Uniform Healthcare Decisions Act. And then again, the information about conflicts related to healthcare instructions and how we resolve those.
Chris, I
Next
just want to
slide.
add one
Oh,
point
yes, go
about
ahead.
the conflict. So this has come up recently, just internally for our hospital, is if there's a conflict, let's say there's an advanced directive and now a healthcare instruction, the healthcare instruction is the last in time. Is that healthcare instruction going to then revoke the entire advanced directive? And the answer is no. The advanced directive would still stand. What would be revoked would be the extent of the conflict. So I just wanted to reiterate that the advanced directive itself would stand. With the other information that's within it, it's the extent of the conflict that is now revoked.
Great point. Thank you. And we'll go to the next slide, please. And here's a little bit more about what's included in statute around advanced mental health care directives. So these are for mental health care only, can include instructions, power of attorney, or both. And here's those guidelines around and again, it's not a specific form that's available. It's just these instructions and guidance provided via statute. So preferences regarding professionals, programs, and facilities, admission to mental health facilities, including the duration of the admission, preferences regarding medication, treatment, refusal to accept a specific type of mental health care, including a medication, and preferences regarding crisis intervention. And unlike the general advanced healthcare directive, the mental health care directive does require two adult witnesses with those same specific requirements regarding, if it's in a long-term care facility, it can't be an owner, operator, or employee of that long-term care facility, can't be anyone named in the instruction or power of attorney that is serving as the witness. So important distinctions to know there in the creation of your advanced mental health care directive. Next slide. So moving into capacity evaluation,
Question in the chat before we move on to evals, just about if verbal healthcare instructions need to be witnessed.
would you
Sure,
respond
yeah,
to that, Jessica?
so technically, under the language of the law, it does not have to be witnessed per se.
Mhm.
It needs to be documented by the provider in the record or in a writing. So you could argue that that is then being witnessed. I would say under policy and best practice, it would be very wise to have it witnessed because we don't have anything in writing to back up the statements. But technically under law, it doesn't have to be. It just has to be in the document. It has to be documented and in the record.
In an emergency before surgery, verbal's okay. Yes, and then that being communicated to the healthcare provider and the healthcare provider bearing the responsibility to document it into the medical record. But yes, a verbal instruction could be given before emergency surgery or anything like that. Good catch. Awesome. Okay, capacity evaluations. So there's an expanded list of who can complete the capacity evaluation, as well as acknowledgement that those completing capacity evaluations need to have specific training and experience and determination of capacity. So these individuals include the patient's physician, primary care physician, psychologist, advanced practice clinicians included, and, physician assistants, nurse practitioners, as well as licensed clinical social workers, all capable of completing and documenting capacity evaluations. The evaluation of capacity is a complex calculation involving a patient's mental status, their cognitive ability, culture, education, health literacy, and ability to articulate the issues of concern. The law is pretty clear on this as well that patients can be found to lack capacity in certain topics or, for certain decisions, but that doesn't mean that they lack capacity fully. So I don't know if we have the exact language on the slides, but I do want you and encourage you to look at that in the capacity evaluation section, that the law is clear that you may lack capacity for, one instance, but that does not does not mean that you lack capacity for making other healthcare decisions. These should be completed and documented with care because, of course, the clinician's professional opinion has profound implications for the autonomy of the individual. These are time and task specific. So again, that's what I was trying to allude to, but capacity evaluations are for a limited duration of time, based off of, potentially a medical diagnosis of delirium or a longer term diagnosis of dementia, and again, being task specific. Next slide, please. So what the practitioner completing the capacity evaluation is responsible to do, as far as notification, they need to instruct the patient that there is a capacity evaluation being done and that it is voluntary, document the reason for the evaluation, again, specifically what area of capacity is in question for the patient, enter that evaluation note into the record, including, and this is written into statute. So again, healthcare providers really need to know and read the statute. The nature, the extent, probable duration, and the outcome of the capacity evaluation all needs to be documented in the medical record. And this needs to be done as soon as reasonably possible, informing the patient of the finding. And then the next slide, we'll talk about the patient's ability to object to the finding of lack of capacity. So this is how, once the practitioner has notified the individual of the finding of a lack of capacity, they also need to communicate and the patient can express back their objection to that capacity evaluation finding verbally written, or another act that clearly indicates the patient's objection. So this is, and I work in an intensive care unit. Patients often have an artificial airway. They're not able to verbally communicate, or maybe in a neurological IC where I work, they might have paralysis of an extremity that affects their ability to write. So there are other means by which patients can communicate. And if it is clear that the patient is objecting that finding of lack of capacity, then the next step will be invoked. But these are the ways that individuals can object to the finding of that evaluation finding or lack of capacity: verbally, written, or another act that clearly indicates their objection. Next slide. So once an individual has objected to the finding of a lack of capacity, um, the they hold on, sorry, I lost my words there, my train of thought. A patient who objects must be treated as having capacity. So again, the evaluation is done. The patient has communicated their objection. Us as the healthcare team must treat that individual as having capacity unless one of the following occurs. The patient withdraws their objection. A court has now been involved and finds that the patient lacks capacity. The patient's condition requires a prompt decision to avoid imminent loss of life or serious harm, or the capacity evaluation is confirmed by a second practitioner. So this is an evolution of the Uniform Healthcare Decisions Act, in which uh, an initial evaluation is done. A finding has been made that the patient lacks capacity. Patient objects. A second practitioner can be brought in to complete a secondary evaluation. If that secondary practitioner confirms the original findings that the patient lacks capacity based off of the task and duration, then that patient is considered to be found to have lack of capacity. But until that second evaluation is made, or one of these other has happened, we must treat the patient as having capacity. So once they object, we treat them as having capacity unless one of these four happens. Want to be clear on that. Next slide, please. The secondary capacity evaluation must be conducted by a practitioner who did not conduct the first evaluation and is obviously not a family member or cohabitant of the first practitioner, so no relation, completely independent of that first practitioner's evaluation and finding. The secondary capacity evaluation is not sufficient to rebut the presumption that a patient has capacity if the patient is requesting continuation of life-sustaining treatment and the capacity evaluation is being used to decide to withhold or withdraw the treatment. So this is a very important distinction for healthcare providers to know, and a big reason why we're talking about this today. This also, in a future slide, Jessica will talk about how there's even limitations of power on surrogate decision makers when it involves the provision of life-sustaining treatment. Again, I'm going to stress that with the secondary capacity evaluation, if it's being utilized to determine provision of life-sustaining treatment, the secondary evaluation determining lack of capacity it is not enough to override, the provision of life-sustaining treatment. I don't know if there's any way to say that, Jessica, clearer, or again, or if you want to jump in and try to stress that as well.
No, it's definitely a tongue twister here. It's just saying that even though on the slide before we said that if one of those four elements occurs, then we could proceed with treating the patient as not having capacity, unless we're dealing with a situation where the care at hand is life-sustaining treatment, and the conversation is about withdrawing that life-sustaining treatment. At that point, then it'd be recommended either to petition the court or have an ethics consult or whatever your policy would require.
And I see a question in here about peer-to-peer. So like in the instance of the first evaluation being made by, let's say, the attending physician, the second evaluation being made by a nurse practitioner, or does it have to be another physician? The law does not state or clearly, the law does not comment on that. So in translation to practice, the primary evaluation, it does not have to be peer-to-peer. A primary evaluation could be made by a physician, secondary evaluation made by a nurse practitioner, physician assistant, licensed clinical social worker, psychologist. That is possible in practice that they are differing practitioners doing the primary and secondary evaluation.
Chris, this is John Goodall. The reality of the situation of withdrawing life support is that usually the patient will not be participating in the decision making. So you're dealing with a surrogate decision maker there anyway, and so the capacity evaluation sounds like it would already be done most of the time.
In that situation, in practice, I would, yeah, absolutely agree with you, Dr. Goodall. And then I think that is it for me. Next slide, please. Yes, Jessica, I'm going to hand it over to you to talk about the judicial review and carry on from there.
All right, thank you. So at this point in this timeline or this process that we're laying out here is the patient, let's just say for argument's sake, does not have capacity. So, or I'm sorry, let me back up for a second, wrong slide. For argument's sake here, the patient is going to petition the court for over the objection over the eval, the psych eval or the attending's eval, whoever is conducting that eval of capacity. So if that occurs, then the court's going to appoint an attorney ad litem who's going to visit the patient, complete a report prior to the hearing, and then report back to the court their findings. The court is going to hear the petition, or at least we hope is going to be hearing the petition on an expedited basis, and then will only determine that the patient lacks capacity if there's clear and convincing evidence. If the court then ultimately determines that the patient lacks capacity, the court will then have to name a guardian over the patient. So when I first started giving this presentation over the summer, we did not have updated court rules. But as of September 23rd, we now have updated court rules for the Court of Chancery. They did add in two new areas for petition to determine capacity, and then petition to enjoin or require healthcare decision-making. And that one we'll talk about in a couple slides. Next slide, please. Okay, so now at this point, the patient has been determined to not have capacity. So who is the decision maker? Decision maker is either going to be a designated surrogate decision maker, which would be a court-appointed guardian, or a patient-selected agent or decision maker that would be found in the power of attorney or a verbal or written advance directive for living will or 5 wishes. Now, the default surrogate decision maker is going to be the one who falls under law in the descending order of priority. And we can go over that list. Next slide, please. Before we get to the list of who can serve as a surrogate, first, I just want to talk about the different duties of a surrogate decision maker. So a surrogate decision maker is going to be able to make healthcare decisions on behalf of the patient as if they are the patient themselves. So they're stepping into the shoes of that patient. However, their decisions should be in accordance with the patient's written or verbal instructions, if any, goals, if known, preferences, and again, known wishes. So if we don't have any of the above, what is a healthcare agent or healthcare decision maker supposed to do? And they're supposed to consider the following. So in accordance with the patient's best interest by considering patient's communications, including past verbal and nonverbal expressions, patient's values, and then ultimately the risks and benefits of the potential healthcare decision that's at stake. And of course, all this conversation can have in conjunction with the treatment team to go over what would be in the best interest of the patient. Next slide, please. So under the new law, there are limitations of what a surrogate decision maker, the extent of their authority, so limitations of the decisions they can make. So under the new law, if it's a voluntary psych admission, unless it's authorized in a written advance directive, the admission cannot be for more than 72 hours. So they cannot voluntarily admit the patient for 72 hours, more than 72 hours, unless this was authorized in a advance directive. They cannot place a patient or approve a placement of a patient in a nursing home for more than 100 days if there are alternative living arrangements that are reasonably feasible. The patient is objecting to that placement, whether verbal or nonverbal, or the patient is not terminally ill. I know this one has come up a lot with our case management. We do have placement where we have decision makers placing individuals in nursing homes or skilled facilities, long-term care that could potentially be more than 100 days. So this has been a conversation point for our institution. And then the last one here, so withdrawal of artificial nutrition, hydration, or mechanical ventilation if the patient has a history of authorizing these treatments prior to losing capacity, then the treatment, and unless the treatment is not considered life-sustaining, the patient provided instructions authorizing the withdrawal or withholding, or the patient is experiencing a major reduction in health and is not expected to recover and has not expressed an objection to the removal. So basically, if a patient is receiving artificial nutrition, hydration, or ventilation, and they have a history of receiving these prior to their inability to make decisions, a decision maker cannot withdraw them unless it falls into one of those categories that we just addressed. And again, that's going to be in collaboration with the treatment team. Okay, next slide, please. This is just reciting what we were just talking about. So just saying here what I just said, that if the person has a long-term disability, has routinely required the artificial nutrition, hydration, and a history of using it, then that surrogate cannot consent to withhold it unless it falls into one of those categories. Okay, next slide, please. So who can be the default surrogate decision maker under law? So what is new now under the statute is that, so the first one obviously has been and continues to be the patient's spouse and now domestic partner, unless there's a petition for annulment, divorce, dissolution of marriage, legal separation, or a decree of annulment, divorce, dissolution of marriage, legal separation. The one that is really new here is the fact that a spouse or domestic partner has deserted the patient for more than a year. So prior to this, if we had legal documentation that a patient was married, either legal traditional marriage, civil union, domestic partnership, we had legal documentation supporting that, that person would be the decision maker. Now we have that if we have reasonable belief to believe that the person has deserted the patient for more than a year, then that person could be disqualified as serving under the spouse or domestic partner as a decision maker. And this came up recently in a case where we had a individual, two individuals, they were married for 40 plus years. However, we then found out that they actually have not been together for the past 18, 20 years. And we found that out because the children came and said they actually have been living separately, not together. They just legally are still married. So that came into play in that case. So then if we are not using a spouse or domestic partner, and next of kin then would go to the patient's adult child or parent. Then after that, this is the new one, the patient's cohabitant. So cohabitant is defined as living together. Hold on one second. So it says two individuals who have been living together as a couple for at least a year. So what that means, living together as a couple, will be up to your best guess. But as long as it has been for at least a year. And I will note that they come in the hierarchy before adult siblings and or grandchildren and grandparents. So even though the statute was updated for it to be permissive so that we could have more individuals who potentially have a relationship with the patient, could have a say into the healthcare decision making, it could cause a conflict if we have someone who has been living with a patient for a year who would have precedent over the adult siblings. And I suspect we will have cases in the future around this. I see the question about conflicts. We will get to that in a second. And same thing about multiple children. I will get to that in a second. There is a specific definition for domestic partner in Delaware, and it's state specific. So Maryland's is different. So domestic partner in Delaware means an individual in a civil union or domestic partnership that is legally recognized in any state. So it doesn't have to be just recognized in Delaware. It could be legally recognized in any state. Okay, so back to the list. I said we have the adult grandchildren, then the grandparents. So here we have what we used to call the friend, the friend affidavit. So a friend who has assisted the patient with decision-making during the preceding 6 months. So now we would have a process where we would have an individual sign a friend affidavit because they didn't technically fall under the next of kin list hierarchy. Now they do fall under the next of kin hierarchy. So we no longer have to use the friend's affidavit. However, in the next slide, I'll show you, or I'll explain how the law, it's permissive to still have affidavits, but it's not required. And then the next one after the friend would be the patient's adult stepchild. So this is new. So because prior stepchildren had no standing. So now if a stepchild was actively parented by that patient and then has an ongoing relationship, that stepchild will fall under the hierarchy now. And then the last one, again, is also a friend who has exhibited special care and concern and then is familiar with the patient's personal values. So that one is very similar to what the old friend's affidavit would cover.
Ask if I can jump in real quick. On the practice side, you know, especially with the disqualification of default surrogate decision makers based off of petitions, annulments, decrees, etc. We certainly don't expect nurses, physicians, social workers, other partners out there scouring court records. The law does state that as healthcare providers, we can make the request directly to these default surrogate decision makers to provide proof of their status. And so I just wanted to stress that because I don't want, nurses or physicians thinking they have to, go out there and be sleuths and familiar with searching court records for these documents. We have the authority to request proof of a surrogate decision maker's status or disqualification of their status.
Thank you. All right, next slide. So to the question that came in the chat, so what if default surrogate decision makers disagree? So under the law, it says that the providers or the treatment team, they need to comply with the decision of the majority of the decision makers of the class with the highest priority. So what does that mean? So if there are multiple siblings, they are all in one class together and the majority is going to rule. So whatever the majority is from that class is what the treatment team should go with. Now, what if the decision makers are evenly divided in that class? Then that's when the treatment team could request additional family meetings to have additional conversations. They could engage ethics at that point if that's under their hospital policy, or the law says any other options available under policy or law. Let me make sure I answered the question in the chat. So yep, the children equal voice if they are all siblings. It gets very complicated when we have stepchildren added in because like you saw, the stepchild comes further in the hierarchy list than legal children or biological children. And then to the conflicts conversation, again, you could have additional family meetings, but you need to go with the majority of the decision of that class. We routinely will engage ethics at that point. If the class is evenly divided, we will engage ethics. Let's see. So you certainly can reach out to other classes of decision makers for guidance, but their opinions will not override that of the higher class. but you certainly could reach out for additional information. How does a treatment team challenge the capacity of a surrogate decision maker? So this does come up frequently, and I always advise that we should not be evaluating the capacity of people who are not our patients. However, when it comes to someone who is a decision maker, we need to know if they can be reasonably available and make decisions in the best interest of the patient. So we could have a very layman evaluation to see if we think that they can satisfy those requirements, being available and make decisions in the best interest of the patient. Again, if there are large concerns, we could always engage ethics to help with those conversations. And then Chris, the next one is about your comment about burden of proof.
Yes, exactly. So based off of what the family or surrogate decision maker communicates to us, we accept that as good faith. We don't have to, especially in a emergent decision is necessary. We don't have to have, or can obtain documentation after the fact of that decision being made. Jessica, I'm going to defer the next question to you because I do not know where adopted children fall legally.
I was just looking at the definitions. So it's not clear. So the definition is just saying family member means spouse, domestic partner, adult child, parent, grandparent, adult descendant. It doesn't say it doesn't go into further details than that. I will say the law clearly does delineate between adult children's and children and then a stepchild, but they're not delineating if the adult children are adopted or biological. That's a great question, has not come up for us yet, but I would like to investigate that more.
And yes, document your disqualifications of surrogate decision makers in the medical record for sure, and the reason for the disqualification.
Yes, to Dr. Goodall's question, yes, I would say adopted children are legal children. I would think the law the statute would consider that as well. Okay, next slide, please. So here's the slide about how could you be disqualified as a surrogate decision maker, a default surrogate decision maker. So here the court finds that the person who is the surrogate decision maker poses a danger to the patient's well-being. The person, the surrogate decision maker is an owner or operator, employee, contractor of a nursing home or long-term care facility where that patient is residing, unless that person is also a family member or cohabitant of the patient. So if that person is a family member or cohabitant first and foremost, and then just happens to be involved with a nursing home or long-term care facility, that's okay, that's acceptable. Now, the next one is, so a affidavit's not required under law, but let's say under your hospital policy, you require any of those surrogate decision makers listed on the prior screen to complete a attestation, and then that person refuses to complete the attestation or affidavit, that could be a reason for disqualification. It is something we're considering internally. It's not part of our process yet, but only because it seems it could be overly burdensome for the treatment teams to have someone sign a document, especially when they need to have decisions made right in the moment. But it is something that we could consider and will consider in the future. Next area would be if the patient has a pending PFA or protection from abuse against the person who would be the surrogate. So if there's a PFA involved, then the surrogate would be disqualified. And then also if there's a civil or criminal order against the person prohibiting or limiting contact with the patient, then that person would also be disqualified. Chris, anything you want to say about disqualification?
I was just thinking about that, Jessica. Thank you. And especially for the healthcare provider, we don't need to be pre-screening for these PFAs or civil or criminal orders. It is a matter of disqualification when it comes up. So for instance, we're using a default surrogate decision maker, but then a friend or an extended relative comes in and says, wait, guys, there's actually a PFA. Then the investigation begins. We don't pre-screen default surrogate decision makers for these. We're not against loose and court orders and things like that. It comes into play as a potential disqualification when we are notified of it, of the potential of there being a PFA or civil or criminal order.
Absolutely. All right, thank you. Next slide. Oh, and I see we're running out of time, so I'll try to be very quick because we have a couple slides. So I'll be very quick about guardianship here. This is just saying that, we get down to the hierarchy list, no one's available, we don't have anyone listed as a decision maker. Then the last resort then is to file our petition for guardianship. This is where the court will then appoint someone to serve and manage the affairs of another, whether that relates to their person or property. There is the Office of Public Guardian, who's the guardian of last resort. They will decline to serve in cases if there are suitable family members or other individuals willing to serve as a guardian. And then what has been updated under the new law is the hospital has always been able to file petition for the appointment of guardian, but the notice provision has been updated under the new law. So now the hospital will have to notify the patient and/or any potential guardians or surrogates that they are going to file or potentially file a guardianship petition. They need to notify them what the basis for the appointment is, so why the person needs a guardian, and that the surrogate is not reasonably available and not able to make decisions on behalf of that person, the patient. There's no less restrictive alternatives available. And so that notice, it says here, the notice has to be no more than 5 business days from when it was determined by the treatment team that a guardian was needed. So as soon as that determination is made that a guardian is needed, no more than 5 business days later is when the notices have to go out. And then what is different now is now the hospital only has to wait 10 business days from the date of that notice before filing their petition for guardianship. Prior to this, there were 2 separate notices that had to go out. Now there's just one before the petition can be filed. Has there been improvement in expediency of public guardians? I'd like to say I plead the fifth, but I don't think there has. But I also, I know they're extremely busy and I don't want to discredit the Office of Public Guardian by any means or the Court of Chancery, but I think it's still a significant wait time for traditional guardianship, not for expedited or emergency. Okay, next slide, please. Okay, so yes, next slide. Next one, thank you. So this is the new area of the law where if a treatment team member or a provider or a health institution decline to adhere to the wishes of a patient or a decision maker, what's that process now? And really this is meant to be supportive, at least I view this as being supportive to the healthcare team. Whereas we learned in the beginning that the presumption is that the patient has capacity and patient's wishes should be followed. That's the guiding principle. That's the presumption that everyone should be following. However, there are exceptions, and now the law recognizes those exceptions and now supports the healthcare professionals in almost voicing their opinions now regarding some of the requests of healthcare that we do see. And so here, a healthcare professional or hospital may decline to follow the healthcare instruction of a patient or a decision maker if the care that being requested is contrary to hospital policy that is based upon reason of conscience, and then that policy was timely communicated to the patient or decision maker prior. That care is something that would not be available at the hospital or by that healthcare professional. The care is contrary to a member of the treatment team's religious belief or moral conviction. Care would be contrary to generally accepted healthcare standards, or that care would then violate a court order or other law. Okay, next slide, please. So if one of these requests come in, then what should the treatment team do? So if the healthcare professional identifies, or the hospital identifies, that they're unable to fulfill the healthcare instruction, they need to promptly inform the patient and or the decision maker of the refusal, and then what are the ultimate options for them. And so the options are that we need to make reasonable effort to transfer the patient to another healthcare professional or institution who's willing to comply with the healthcare instruction. If the healthcare instruction is refused because it's contrary to policy or requires care that is just not simply available at the hospital, then the professional and the hospital need to continue to provide life-sustaining care that's consistent with accepted medical standards until the transfer is made. Now, the law put a line in the sand between what I just read and what I'm going to read, and I'm still having a hard time trying to figure it out myself, so bear with me. So we just heard that if the refusal is because of contrary to policy or care that wasn't available, then we have to provide the care, life-sustaining care, until transfer is made. But in the next one, if the care being requested was because it was a violation of it was contrary to a member of the team's treatment or religious or moral conviction, contrary to generally accepted healthcare standards, or violation of court order, then it falls into this last category. And the treatment team reasonably believes that transfer is not feasible, then the professional and hospital need to continue to provide life-sustaining care that's consistent with accepted medical standards for at least 15 days after the refusal. So now under the law, we have a time frame, 15 days. Prior to this, we had our medical ineffectiveness law under this section, and that did not provide a time frame, but now we have a 15 days. But it only applies to 3 of the 5 categories. And that's what I'm still trying to figure out why, and the reason for that. Let's see. And so what we have created a policy based around this new law, and part of the policy is during that 15-day window, we will work for transfer, we will have an ethics consult, we will have family meetings, we'll engage in any meaningful conversations we can. And then ultimately, if transfer is not available, and if the family did not request an injunction from the court, then at the end of the 15 days, then that care can be discontinued. Okay, let me see if there's any. Okay, nothing indirectly related to that. So let's do to the last slide, and then we can finish with questions. So I like to summarize and end this presentation with the slide on immunity, because I know everything we just told you is a lot of information. It's a lot for the caregivers to now have in the back of their head that they have to try to comply with everything that the law is setting forth. So I'd like to finalize and just say that there's an affirmative defense. You have immunity. If you're a healthcare professional or an institution, you're acting in good faith. You're not going to be subject to civil or criminal liability or discipline for unprofessional conduct. If you are in good faith complying with the healthcare instructions or refusing to comply with the healthcare instructions made by a person, if that refusal is based on the belief that that person did not have authority, complying with advanced healthcare directive based on reasonable belief that it's valid, and then refusing to comply because it's not valid, and then determining that an individual who might be authorized to act as an agent is not reasonably available. And that's what Chris was alluding to earlier about disqualification. So again, you would have immunity as long as everything is documented well and you were acting in good faith. And we are exactly at 1 o'clock. So, but I certainly, next slide, we certainly can answer any questions. And then here's our contact information if you want to discuss further, anything else comes up.
Wow, you guys, that's a lot of stuff. Any other questions before we wrap this up? I know that we have a plan. This entire recording will be on the Delaware Quality of Life website, probably by next week. and certainly is accessible to people that want to follow up and go through some of this information again. Any other questions that we want to address right now, or should we let everybody get back to their work?
There's one question that came in from Keith, and is a great question. It's one that we have been tackling ourselves internally. Yes, so the EMR does allow you to document who would be the decision maker or agent or whatever the language is that your EMR has. But these are not witnessed. So what we have advised is that they can be entered into the record, but that the treating or the attending provider should confirm that with the patient and then document the confirmation.